Good afternoon, everyone. I'm Neville Johnson in Beverly Hills. I do entertainment, media litigation, class actions, and I have been on both sides of legal malpractice actions. And we're pleased to have two top speakers here today. Marshall Cole is at the firm of Nemecek and Cole, which is one of the preeminent malpractice defense firms in Southern California. Ellen Pansky is a legend and is the one of the non-pareil defender for people who get in trouble with the state bar. We're going to have Marshall giving us a PowerPoint, and Ellen and I will be commenting, and then Ellen will have some time at the end to talk about the state bar. I'm just going to give you some headlines now and general thoughts for a few minutes, and then we'll get into it. First, clients are not your friends. Get used to it, dig it. You will be invited to their weddings and their bar mitzvahs, and you will go on travel places with them. But when the money comes in, how common is it that any lawyer could have done that? And they're going to be bitter and try and cut you down. You are fiduciaries. And if you look at it in life, generally speaking, you have your immediate family, one or two other maybe close friends, and that's about it. Everybody's acquaintances. So consider how many people are truly your friends after you stop representing them. And that's the way it should be. You're a fiduciary. You got to put put them ahead of yourselves at all times. One of the things we'll be talking about is taking a percentage. You got to get it in writing. We'll talk about the cases where what happened when they didn't. Conflicts of interest, particularly in the entertainment industry. If you're representing a director and a producer in the same situation, you need a conflict waiver. We'll be getting into that. Referral fees, you got to get it in writing, and Ellen's going to tell you why, because there's rules. Fee shifting. What is the deal when there is fee shifting? Do you have to tell the client? What is an unconscionable fee? Do you have to advise the client if there's a possibility they're going to get hit with slap or copyright fees if they lose? What's the current climate for the state bar? And how do we want to handle fee disputes? Do we want to have a malpractice clause overall? So with that, take it away, Marshall.
All right. Good afternoon, everybody. It's nice to be speaking here again alongside my two favorite colleagues. Let me get this ready to go. All right. So where we like to start this presentation out is with a little bit of a scare tactic for all of you. This was a survey. It's done by a broker firm called Ames & Go. They put out the leading survey in relation to legal malpractice claims. They actually did just come out with an updated one. I didn't have time to update this slide, but the statistics are largely the same for 21-22 with respect to the massive payouts that are being made by insurance carriers in defending legal malpractice claims. And of these 11 leading legal mal insurers, I'm sure many of you out there are insured by these very companies. And I think it's important to focus on the size of the payout, the amount of claims that are in these figures. And what we're going to discuss today is one of the hot causes of action, which is the breach of fiduciary duty claim, which stems directly from, as Neville pointed out, a conflict of interest cause of action, which not coincidentally also listed by the Ames & Go firm as the most popular cause of action to plead in a legal malpractice claim that causes one of these types of settlements. So as we go forward, there's one key case, and Ellen, I know you kind of talked about this case and like to talk about this case, which is the Shepard-Mullen case, which really kind of changed the landscape as far as how law firms get treated with respect to their fees. And so, Ellen, if you wanted to talk about this case for a moment, I invite you to do so.
Thank you, Marshall. Again, I'm also very honored to be here. Thank you for having me. So everybody should know, and I just want to take a second to remind you that in California, we are governed by the California Rules of Professional Conduct and also by the State Bar Act, which is Business and Professions Code section 6000 et sec. The rules that you studied when you took the National Committee of Bar Examiners test, the MPRE, are not California rules. So if you haven't looked at the California rules, please do. The current rules were adopted effective November 1, 2018, and the conflict rule is 1.7. If anything, the current conflict rule is actually more stringent than the rule that was applied in the Shepard-Mullen case. So it's very important that you understand a couple of key points. Number one, if you are representing more than one client in a matter or related matters, that is a potential conflict. It doesn't matter if you're talking about, as Neville mentioned, a director and a producer in the same project, or multiple talent personnel in the same project. If it's more than one client, you must get a conflict waiver. In California, Rule 1.7 treats potential conflicts exactly the same as an actual conflict with respect to the need to get conflict waivers. The earthquake of concern that the Shepard-Mullen case caused was that the law firm was representing a client in one matter, and then in a completely unrelated matter, in a different geographic area within California, different branch office of the law firm, the case began to represent an unrelated client against the client who Shepard-Mullen was representing in Los Angeles. And what the Supreme Court said is that this implicates the duty of loyalty, even if there was no evidence that the firm used confidential information that it knew about its pre-existing client in connection with the representation of the adverse client in the unrelated matter. It's a duty of loyalty that precludes the lawyer from accepting representation adverse to a current client, essentially in anything, unless there's informed consent. Another issue that was huge in the case is that Shepard-Mullen, as many firms do, if not most firms, had a conflict waiver provision in its retainer agreement. And the provision said, you understand that we represent lots of people, lots of clients in this industry, and we may be representing another client that's adverse to you. And by signing this agreement, you agree, you consent that we may do so. However, the provision in Shepard's contract also said, if the situation arises where we are going to represent another client against you, we will come back to you. We will disclose that, and we will obtain your subsequent consent to that particular matter. And the court kind of glommed onto that and said, oh, Shepard essentially made a representation to its client that if the situation arose where they were going to be adverse, they would come back to the client and they would get a supplemental conflict waiver after they disclosed that specific conflict situation, and they failed to do so. And then the shocking takeaway of the case, at least to many in the legal profession, is that the court said that when the lawyer breaches a fiduciary duty to the client, such as the duty of loyalty, then it doesn't matter if the lawyer provided valuable services to the client. The conflict renders those services unenforceable. So the Supreme Court remanded this case back to the lower court to determine not only what the Supreme Court determined, which is Shepard-Mullen should forfeit every dollar of legal services it provided that the client had not yet paid for, but also whether Shepard would be called upon to disgorge any portion of the fees that it had previously been paid. And the turning point there is what services were provided before the conflict arose. A law firm is entitled to be compensated for those services, but if there are any services rendered after the conflict arose, the Supreme Court seemingly said the firm will forfeit and may be called upon to disgorge fees already paid for anything that they did after there was a conflict.
And certainly when there's a finding of potential disgorgement, when you go and prove up your quantum merit claim as the law firm, your hourly rate may be much lower than what you otherwise would have contractually had an agreement to be paid. So that's something to really be conscious of. And so when we look at the fiduciary duties and the conflicts in play, these are the basic list of your fiduciary duties. And I think most importantly for the group we're speaking here today, as Neville pointed out, it's joint representation of multiple clients. And you can have joint representation. You certainly need to have a conflict waiver at the outset of that representation. And it shouldn't be some boilerplate document that you have from client to client. You really want to tailor it to the specifics of what you believe the potential conflicts might be in the particular representation, because the more detailed it is, the more informed of a decision your client or clients can make. And so, and that goes right to the exercise of independent professional judgment. I mean, you really want to think about what the potential conflicts are. And then as the representation gets underway, and maybe a year or two later, maybe there's new potential conflicts that come up that didn't exist at the outset of the representation. You want to renew that waiver and advise them and get informed consent. Hey, these things are no longer in play, but hey, both of you need to be aware that there's now these various aspects that could be a potential conflict, and I want to get your informed written consent. And that is just the best practice to do, and it will keep you out of trouble, because as I put in red here on this slide, that a breach of fiduciary duty claim, and in particular an intentional breach of fiduciary duty claim, is really a hot cause of action to assert against attorneys, because as you'll look at the jury instruction on breach of fiduciary duty, and this is the intentional breach of fiduciary duty jury instruction. What's most shocking to me is the word intentional doesn't appear anywhere in it. It's not like fraud. You don't have to intentionally act and intentionally cause harm. The elements are much easier to prove. And the biggest problem with this cause of action is the causation standard. Normally, in defending a legal malpractice claim, even if it's a negligent breach of fiduciary duty claim, the plaintiff has to establish but-for causation and do the case within the case. But for the lawyer's conduct, the plaintiff would have received a better result. But with an intentional breach of fiduciary duty cause of action, they only have to establish that the conduct was a substantial factor. And that is much easier for a plaintiff to establish, especially in cases involving trust accounting issues, where money may have gone missing. Conflict situations, right? If you don't get a conflict waiver, it may be a negligent act, but you certainly did it intentionally. Absent you just basically being asleep while you're doing it, a judge is going to allow this jury instruction to be read. And if
Marshall,
this
can
read, go ahead, Ellen.
I was just going to jump in. I didn't mean to interrupt you.
No, go ahead.
I just want to kind of go back to the prior slide. Marshall identifies an important consideration that I think a lot of lawyers overlook at the outset of representation. You can play out in your mind a possible scenario where your multiple clients may come into conflict with one another in the future. If you're representing multiple clients and negotiating terms of their contract, for example, their experience level may be different. Their skill set may be different. So the value of the services, of the skill that's being brought by one of your clients may be much higher than another. And so if you see that as a possible issue, you need to think about the fact that if things go bad later and one of your clients become disgruntled and they're going to try to find somebody to pay them for what they perceive as their damages that they suffered, the lawyer's going to be first in line. You know, you can take that to the bank. And so some of the allegations that would be made against the lawyer are, you had confidential information from the other client that was material to your representation of me. You concealed that from me. You had a duty to me. You didn't tell me that you weren't going to share that information with me, and thereby you breached your duty to me. And a lot of times, or maybe they don't get along, you know, from the outset that these clients have strife with one another, and you can see that they may not be the best working partners. There's any number of things that you might identify going in. And so my advice to you is you need to make a decision before you accept representation of the multiple clients. Is it worth it to accept more than one client in this representation? Or would you be better off saying, I can represent one of you, but I think it would be better if the other of you gets independent counsel? And, a lot of times you're taking somebody on as what the ALA treatise of the law governing lawyer calls the accommodation client. So you have your main client, maybe you represented this client before, and then there's the new client, or the client with the less valuable contract, however you want to characterize that, who you're going to take on as an accommodation. Maybe you don't want to do that. Maybe you want to minimize your risk. And then the last thing I want to say is, again, Marshall mentioned, when you get the conflict waiver, it must be in writing. In California, unlike some other states, it's not enough for you to send an email or text saying, this will confirm that we discussed the conflict and you agreed to waive the conflict. There must be a writing signed by the client. So you need to make sure that you follow up and that you document and make a record of the fact that your client consented. If you're going to provide legal services by text, which I'm old and I don't like and I don't recommend, at least make sure that you save that somehow in a file so that when later the issue arises, you can access it.
So as we were talking about this particular cause of action, and I had a case where defending an attorney, he represented an individual in a personal injury action, and then associated in to represent another plaintiff in the same action. Well, his original client didn't know that because my client didn't get a conflict waiver. And the unfortunate situation we found ourselves in was this jury instruction. We claimed it was negligent. He just didn't think he needed it, but nonetheless, it was an intentional act. He didn't do it. And so we were on the wrong side of this jury instruction. And also what comes with this jury instruction is emotional distress damages. This case, Knudsen versus Foster, it's a 2018 case. It's been around for a while now, is a really problematic case for lawyers because it holds that a plaintiff can successfully obtain emotional distress damages from a lawyer as a result of their conduct. And even more important, they don't need to go and seek mental health services. They don't need to be on medication. They don't need to have an expert come and testify. They can get on the witness stand, cry, and explain to a jury how the particular lawyer did something truly awful to them. And this is extremely important because many of you can imagine when you retain a client, they're coming to you for what could be the most important contract of their life, the most important deal they've ever made, an extremely important piece of litigation. Whatever it is, generally people are coming to lawyers for something serious. And so if it gets screwed up, or if the lawyer has a conflict that they didn't disclose, this case is going to come right into play because clearly that person is going to be upset about the fact that the lawyer didn't disclose it. And it's real easy for a plaintiff's attorney in a legal mal case to sell this to a jury because jurors are pretty unsympathetic as far as lawyers go in general. And then when they get up and they start arguing what the lawyer did and how they disregarded the client's interests, and then the client gets up and is crying about all these things, the jury's going to sympathize. They will sympathize. And if you don't do things the right way, they have a right to sympathize. And what's really important about emotional distress damages is they're not likely going to be covered by your malpractice insurance policy. And generally speaking, intentional torts, intentional claims are uncovered acts. So it's really important that you do your best to keep yourself out of a conflict scenario or anything that's going to find your way into a breach of fiduciary duty cause of action. A legal malpractice claim is a totally different animal from the Knudsen versus Foster case and breach of fiduciary duty. And I think we've kind of gone through this, but most importantly, and I think for this group, It's sort of representing multiple clients in a single matter, and also representing a client number 3 adverse to a former client in certain matters. And it can be done, but you need to make sure you have conflict waivers in place. Ellen, did you want to add anything, or Neville, before I move on?
Well, I just want to draw attention to the comment that you've included. Independent counsel does not mean another lawyer in your same firm. There are cases where, you know, the lawyer sent the client down the hallway to their buddy. Courts don't like that either. So if you are going to, well, let me just stop for a second. The conflict rule itself does not require you to say to a client, you have the right to independent legal counsel. When you're engaging in some sort of business or financial transaction with the client, that's the kind of conflict that absolutely requires the lawyer to tell the client you have the right to independent legal counsel and to give them a sufficient opportunity to obtain that advice. It's not required that the client actually obtain it, but they have to at least have the opportunity to get independent advice. In the conflict situation, even though it's not in the rule, if you are going to represent multiple parties and you can see that their interests could diverge in the future, it doesn't hurt, and it may help you to put the additional language in your conflict waiver. You have the right to seek independent counsel, and I encourage you to do so before you make a decision whether to waive this potential or actual conflict of interest.
And I want to say that whenever there's a loan out corporation or a wholly owned corporation by the individual client, which commonly happens, you must have a conflict waiver in that particular situation. Additionally, I had a case that was settling one time, and I had like 10 clients, and they were all saying, I suffered more. And that was hellacious. And then there's a case that I can tell you about, my personal knowledge, where the client said, I do not like what the co-plaintiff in this particular situation is asking for or wants, and I want out of this relationship overall. So it can occur in that way as well. But you've got to keep those clients informed of what's going on, what the conflicts are, and typically when you're representing people in litigation in the entertainment industry, you've got to explain to them that, look, you may have one of you may want to settle, the other may not. How are you going to handle that? And so one of the opportunities is to say, well, one can go off his own way or her way, and I will maintain the other client. It won't be determined to be a conflict. And if there is a fight later on, you know, the attorney-client privilege is more or less waived as between what's going on in this situation.
And so there's
let me just follow up on that for one moment. It's also important to keep in mind that there is some authority in California that the lawyer may ethically procure an advance waiver from the clients for a future conflict. There's a case called Zador versus Kwan. It's been cited many times. The law could be a little clearer in the area, but the case law seems to say that the lawyer can say to the client going into the representation, you understand that I have a pre-existing relationship with this client, or I'm also going to be representing this other client. And you understand that when two clients are being represented by one lawyer, I'm going to share information. We're going to harmonize the representation. We're going to promote both of your interests. And that if you were represented by your own lawyer, that wouldn't occur. Anything you told your lawyer would be maintained in strict confidence and wouldn't be shared with anyone else without your consent. And you also agree that if a conflict should arise between you in the future, notwithstanding the fact that you have given me confidential information that I might use against you, you consent to allow me to withdraw from representing you, or if you decide to terminate our relationship, that I may continue to represent client number 2, and that you will not raise any objection to my continuing representation of client number 2. And typically that sort of advance consent and consent in advance to waive a future conflict, at least according to the case law, will be upheld.
So there's a
Say
question.
one other thing about loan-on corporations. A big problem that has occurred is that you cannot, when there's a loan-on corporation and a copyright has been transferred by the individual, you're not able to recapture it under the copyright law. And that's something that everybody better be aware of who's in entertainment law right now to explain that potential problem.
So there's a question, which is, can you include the conflict waiver within the engagement agreement, or must it be a separate document? It's a good question. I think best practice, and certainly how I practice, is it's a separate document. I think you have a retainer agreement, which outlines the scope of the representation, the terms of the representation, and then a separate document as a conflict waiver. I think they certainly could be included in one, but I think that you risk a client saying down the road that there was a lot of information in one document, and whether they gave informed written consent versus just signing it. I think there's some differences there. Ellen, what do you think?
I agree. I recommend a separate document. And in a lot of practices, it's typical, for example, in personal injury plaintiff's work, it's both in the retainer and there is a separate conflict waiver. If you're going to include it in your retainer agreement and not as a separate document, I then would recommend that you put an initial line where the client is specifically initialing consent to the conflict waiver. At least then they can't say, oh, this was a contract of adhesion, it was buried in the body of the agreement, I didn't see it. One last point is sort of another, in the category of an anecdote. I was once an expert witness in a legal malpractice case in which the opposing expert said there was too much detail in the conflict waiver and it was too long. And because of that, it was confusing to the client and it shouldn't be given force and effect. That argument failed. I think, from the malpractice defense point of view and also the state bar defense point of view, the more detail you can put into your conflict waiver of the potential conflicts that might arise, the better it's going to be and the more likely it will be held to be a valid and effective waiver.
Yeah. And I think if you're going to have it in one document, it sounds to me like it's probably going to be a boilerplate type document, which kind of just sets off red flags. Whereas if it's separate, you might have a retainer agreement that's somewhat boilerplate, which is a different story versus what your conflict waiver needs to have. So I just think separate is going to just trigger in your mind to do more and provide more detail. So these are obviously the consequences of what could happen. I think we've discussed pretty much all of them. Some of them fall under the Shepard-Mullen case of things that can occur: disqualification, forfeiture, and disgorgement. Voiding of a retainer agreement certainly can happen, and I have defending a case where it's happened in that case. And if you have an outstanding receivable in that scenario, you're likely going to be relegated to a quantum merit prove up versus a contractual entitlement to fees that were agreed upon. And the retainer agreement can be voided for a number of reasons, depending on what's alleged and what the violation of the business and profession code might be. And down the line, you can see all the other ramifications that can occur. So it's certainly something you want to avoid. And then as we sort of switch gears to talk about billing, I think another really hot area that plaintiffs' lawyers in my field are going after is looking to the bills. And it's certainly something they've always done, but I think bills now, especially with less oversight of associates and attorneys who you might work with because they're working remote, it's harder to see what they're doing. And I think block billing, certainly reconstructed billing or value billing, are things that I'm seeing more on bills when they come into our office, which are just huge red flags. And plaintiffs' lawyers can have a field day with bad bills. So all of these 6 issues, if you do them, I'd recommend you don't. I understand block billing. A lot of you might do that. A lot of firms might practice that way. There's nothing wrong with billing your client that way. But I think when it comes down the road for you trying to get the reasonable value of your services or just the contractual entitlement to fees based on those bills, an opposing billing expert is just going to rip them to shreds. And you'll be lucky if you get 25% of a particular billing entry that's block bill, just because the client really can't see what you're doing.
On that issue, I just want to add, from the state bar point of view, the state bar is not supposed to get involved in fee disputes. That's beyond the purview of the disciplinary system, but they do. So we get to what Neville mentioned at the introduction, which is whether the fee is unconscionable. Again, California differs from some other states. Some states use the standard of reasonability. Was the fee reasonable? We actually have a standard that's a bit more favorable to lawyers. Was the fee unconscionable? And unconscionable means so exorbitant that there is no real relationship between the service that was provided and the amount that's being charged for that service. Now, that doesn't really apply in the contingent fee situation, because a contingent fee, by definition, has risk. And so the analysis is, if a lawyer is charging a contingent fee, the lawyer's on the hook to complete the services for that fee, regardless of the amount of time it takes. Sometimes the lawyer, hits a home run early in the case, settles the case, hasn't put a lot of time in, and in that case, the so-called windfall goes to the lawyer. But on other occasions, and this is not uncommon, the lawyer has to put in hundreds and hundreds of hours or more, and their effective hourly rate is, $50 or $100, way less than what a quantum merit or reasonable value might be. And so for that reason, generally contingent fees are upheld, even as high as 50%, depending on the amount of risk and the novelty of the legal issues involved and the difficulty of the case. So there's that. But when you're talking about billing on an hourly basis, the real question is, are the fees within what would be considered a standard rate? And as we know, in Los Angeles now, there are lots of lawyers who are charging well in excess of $1,000 an hour. So it depends also on what's the level of the lawyer's expertise. Is this something that was revealed to the client? Did they agree to it at the beginning of representation? And can it be justified in terms of, it's a multi-factor test. So how much time was required? Again, what was the novelty of the issues? What was the result obtained? Marshall mentioned a bonus or a performance related add-on. I don't think that the legal profession has embraced that idea, but I do think that, again, if it's in the contract, if the client agreed to it, if the lawyer achieved an extraordinary result, then that may be an enforceable provision. One danger area that a lot of lawyers don't think about is what happens when they want to increase the fee. Let's say that you started a relationship with the client, you got a written retainer agreement, and you've been representing that client for a decade or 2 decades, and now you want to raise your fee. There are some legal ethicists who say, no, you signed a contract, this is what you agreed to do, and you're stuck with that. I don't agree. In my opinion, and I think the case law supports the idea that upon reasonable notice to the client, which generally would be not less than 30 days, a lawyer can say to the client, we are raising our fees. If the client doesn't agree, that's fine. The client can go hire another lawyer. But what the lawyer cannot do is unilaterally raise the fee without notice to the client and without client consent. And that's a trap that a lot of lawyers don't think about. They just raise their fees, and later, as Marshall points out, when the opposing expert goes through the bills with a fine-tooth comb, that's one of the things they're going to be looking for.
And there's another question here regarding block billing. Question is, sometimes I call and email clients while I'm drafting and or reviewing documents. I turn on the timer at the start and turn it off when I'm done. Are you saying that I have to separate out each task under this scenario? So assuming you're reviewing and drafting the documents for that particular client that you're also calling and emailing, you can bill it as a block bill, but I think just your best practice would be to separate out the tasks. And I know it's going to create more time in entering your time. If you have 0.5 in calls and emails, and then you spent 5 hours drafting the document, you got a total of 5.5, but they're separated out versus 1 5.5 hour entry that just says review documents and talk with client. I think that's a little more basic of an example, but it can get a lot more complex where you're talking with opposing counsel, you're dealing with the same document, you're calling and emailing your clients, then you're doing something else. The more you have in one entry and that just have a big old number at the end, I think that's the bigger red flag. If it's that simple of an example, I don't think it's really going to be a problem. And again, block billing only really becomes a problem when you're in a legal malpractice case or you've got a fee claim and there's going to be an expert involved, and that's when the block bills are going to be toast.
Let me just say, I've testified on the issue of block billing many times. And while I don't disagree with anything Marshall has said in terms of a best practice, the fact is that there are a handful of cases, and they're mostly federal cases that, strictly speaking, aren't binding in a state court, that criticize block billing. But if you look carefully at those cases, they're talking about the type of entry, which is trial preparation 8 hours, work on case 5 hours. Generally that's the type of non-specific billing, which is what is challenged as block billing. In the example in the question, I would have no problem with putting your finite amount of time that's the actual amount that you have tracked, that you've done while working on multiple tasks. What I've done, I'll just share with you, is I have an actual contract provision in my retainer agreement, which explains, you agree that I made you block billing. And the reason for that is I've seen abuses where you've got firms that say, call witness A, 0.1, call witness B, 0.1, call witness 3.1, when in fact the lawyer they did call those 3 individuals, they left a message. And if you block billed it, maybe you would bill 0.1 for all 3 calls, 6 minutes for all 3 calls, as opposed to breaking it out. So from my point of view, there can be abuses on either side, but to the extent you can break it out, do so. It'll save you a problem in the future.
And as we go forward, these next few slides were put together with myself and a colleague of mine who's on the plaintiff side of the cases I handle. And these are basically the themes that he looks for in legal mal cases. This is everything. When he gets a case or when a client comes to him, does he see one or more of these topics that he can get to? Of course, he's looking for breach of fiduciary duty, but the one that I like to focus on is incompetence and really puffery to attract clients. And one of those ways that people do that, or lawyers do that, is through their websites. And if you advertise, if you have a website, I'm sure most of you do, you better make sure it's accurate. You better make sure that it's, not containing information that's really old. I mean, certainly don't put something you didn't do, but even if it's really old, if it's 20 years ago, it's not okay to say that that's something that's current, right? You can put the date and then they can see that that was old, but if you start to mislead the type of lawyer you are, what your practice is, how good you really are. I mean, if you say you're the best lawyer in the world, which many websites say that, it comes back to bite a lot of people because they may not have experience in the particular field that they end up getting sued in. So I think that's a really important thing to take note of. Go back, look at your website, make sure the information's up to date, all the awards that you've received are accurate, and then continue to put it out to the public. But these are some of the themes that play out well and are difficult to defend against in a legal mal case.
Also, they're difficult to defend against in a state bar discipline case. The state bar does investigate complaints about lawyer advertising. It sometimes does come up where an individual client complains, there's a laundry list. The lawyer didn't represent me competently. The lawyer had conflicts of interest. The lawyer settled the case without my approval. The lawyer misled me as to their experience and abilities. So the state bar would definitely look at that. But in addition, the state bar will look at websites, because anything in writing that offers the legals or advertises the legal services for pecuniary gain constitutes an advertisement in state bar land. So I have defended lawyers who got anonymous complaints regarding their billboard. And so if you're going to use puffery, if you're going to say #1 lawyer, or if you're going to say voted #1 lawyer, the state bar may ask you to prove that. And if it's inaccurate or you cannot document it, that can be a problem.
You can't just hold a vote in your office and determine that you're the #1 lawyer. So these are additional fact patterns that play out, and these kind of go to a lot more billing issues. So, separate and apart from just block billing, which is kind of the common one, these are other things that occur. And again, that plaintiffs' lawyers are looking for. You've got, is there a third lawyer who's just billing time that's not necessary? Me 2 hours, meaning, just even a second lawyer billing to review the same document, billing to revise the same document. And generally speaking, and certainly in my practice, I'm generally have 2 lawyers on a case, and the 2 lawyers cannot do the same thing, or it's going to raise a red flag for my clients. Got 1 lawyer drafting and things, and then maybe you can edit and revise. But the more people you have doing something on a case, and certainly it may be warranted. This isn't saying, we're not saying you can't have 3, 4, or even maybe 5 lawyers, depending on the matter. But you want to make sure that when you look at the bills at each month, that they show a nice roadmap that can give the client an idea of what's been going on, who's been doing what, and have I just been paying for the same thing? And if you're not doing that, or it's pretty clear, then you're perfectly fine, and you're not going to fall into any of these pitfalls regarding some of the things that are these lawyers are looking for. And meeting hours and quotas and bonus levels, there's not much you can necessarily do about that, depending on how your firm may allocate bonuses to lawyers. But the idea there is, if you have a bonus that kicks in at a certain hour increment of 2,000 hours or whatever, the implication is obviously that the incentive is for any lawyer to just pad their time and add hours, because they don't get a bonus unless they meet those quotas. I don't agree with that argument. I haven't seen it really play out in any extreme example, because as long as the bills accurately track the time and the work was, commensurate with the time that was involved, you're going to be fine. But these things are out there, and I think it's important to be aware of them.
And if I can add to that, you want to make sure that your bill doesn't include charges for training your staff. That's not appropriate. Obviously, when the firm has, or a lawyer has, a new associate or a paralegal, there's nothing wrong with having that person work on the file, and there's nothing wrong with reflecting their time on the bill. But what you should do is either include that as a no charge entry, or reduce the amount of time. I often, if I feel that my associates have overbilled for a task, or even that myself have spent an exorbitant amount of time on something, not because it wasn't warranted, but it just ended up being more than maybe originally contemplated, it's certainly permitted for you to do a courtesy fee reduction, but reflect it on the bill so that the client knows that what you've done is you reduced that fee. And then later, if you have any kind of issue with the client, or they're complaining about the amount of fees, you can go back and you can say, well, look, you can see that I've already reduced my fee, in recognition that this matter ended up being costly. We've already given you a courtesy fee reduction. And, it is, you'd rather do that and take the proverbial haircut than end up in a lawsuit with your client or defending a state bar complaint.
And I think showing a no charge is just a great thing to do for your clients. It shows, it's just goodwill. It's such an easy thing to do for some of those calls that you have. If you're working on the document at the same time, break it out and show a no charge for it. I mean, it's just goodwill. It's money in the bank. It's great to do. I think, this slide discusses certain aspects and then better practices. And I think following these better practices is going to keep you out of trouble across the board. And so this next slide, I should have renamed it the COVID slide, because this is basically, I've now officially seen cases with respect to all four of these topics all come out arising from the remote workplace environment, which was basically created in the last 2 years. As Ellen points out, you shouldn't be texting legal advice. I completely agree, because when you do, you're generally saying something like what's on this screen. And that's not good advice. You're not getting clear answers. You're not providing clear information. And then taking screenshots of text messages and then sending them and using them as evidence is not a position you want to be in, as far as, oh yeah, my client agreed to the settlement. Well, do you accept? Yes. Accept what, right? I mean, that's just lazy, and you should just use email or in-person conversations and get things in writing. Cyber insecurity is a big issue. If you're working from home and you're using personal email, or you're just on an open internet line in your house, your network is totally vulnerable to a cyber attack, and your information will eventually be compromised. There is so many types of spam emails that come in, and working from home requires an extreme amount of diligence that I'm confident most people don't undertake because it's expensive to do. So just be aware of that. And there's certainly cyber insurance policies you can go look at, but they're capped. And if you get locked out of your system, you're going to have a lot of explaining to do to clients with respect to deadlines, and you can't access information. I think same goes for associates. Everyone's working from home in certain firms, and really no one has a clue what their associates are doing other than hoping that the work product comes in. But the bills and the work product aren't exactly adding up. And then the last point is be technology competent. And I say that at the most basic level, which is, if you are going to participate in a Zoom conversation or a Zoom meeting or a Zoom deposition, know how it works, know how to share a screen. You have to know these things. It's no longer funny. And if you make a joke on the record, it doesn't read like a joke when you read the transcript. When you say, oh, I don't know what I'm doing, or I'm an old guy and I don't know what I'm doing, it doesn't play out so well on the record, and it's not funny. And your client is sitting there saying, wait a minute, I just hired a guy who can't even operate Zoom, or a woman who can't operate Zoom, or a woman who can't operate PowerPoint. How are they supposed to effectively advocate for me? So technology competent is a very basic principle, and I can't count how many depositions I've sat in over Zoom in the last 2 years where everyone says they don't know what they're doing. I think that's just unacceptable at this point in time.
Let me add a sort of related issue, because it's in the news now. There's a big issue now relating to whether and the extent to which lawyers can protect client identity. And there's a difference of opinion whether the identity of your client standing alone is or is not privileged. The SEC has subpoenaed the Covington law firm, seeking to compel them to reveal the identities of clients who were hacked. So it wasn't the law firm that was hacked. The clients were hacked, and the law firm is representing these clients in connection with those incidents. And the law firm is defending on the grounds that that's confidential information. So this issue of cybersecurity is it's something that's in its infancy. I've also had the situation where law firms have been hacked, and they have been able to determine that, in fact, no sensitive information was actually obtained by the hacker, but it raises ethics issues like, do they have to tell their clients? What do they have to tell their clients? How soon do they have to tell their clients? So if these technology or cybersecurity issues arise, it's important for the lawyers not to bury their heads in the sand. If you don't know what to do, you need to get advice. I do recommend that you check into having a cybersecurity insurance policy. They're not that expensive. And if you are unfortunate enough to get hacked, at least you have some coverage. So that might be something that benefits you to looking into.
Yeah, there's a question here. Ms. Daly, I'll get to your question in a minute, but so the other question is most, not all, but 5% or so talent lawyers do not keep track of their time. Wouldn't it be wiser to do so, even if you're not hourly billing, in case you're put in the position of having to make a quantum Merowick case? So I'm assuming that the lawyer in that instance is getting paid on the back end of the deal or some type of compensation arrangement. I think the answer is yes. I mean, if you kept track of your time, I think that's a good thing. You don't have to send it to your client, but if you contemporaneously keeping your time or keeping track of what you're doing, and then if something blows up with that deal and you want to get paid, yeah, you've got a roadmap of what you were going to do. And in deposition, you'd say, I wrote it down. I have custom and practice. I do X, Y, and Z. I'm not billing my client, but I'm keeping track of what I do. So I think absolutely. And I think personal injury lawyers fall victim to this problem all the time because they work on a contingency. They notoriously don't keep track of their time. And then they're left trying to recreate everything they did, go back and look at depositions and discovery. And you're certainly going to miss things. And it would just be a lot easier if they did it contemporaneously. But I'm sure 90+% don't do that. But again,
and also, there's a related issue, which we don't have time to get into, and probably we should do an hour panel just on this. But there's another ethics/malpractice concern when the lawyer is getting a percentage of a project in perpetuity. And the client decides to fire that lawyer, and the lawyer says, well, you can fire me, but I'm still going to get my percentage because I got you this project and that was our deal. So, again, if you find yourself in that situation, that's something that you might want to get some advice on before the matter devolves into litigation.
Yeah, and I want to say that I've seen that recently, and the lawyer better put it in his contract that he's in, even if the client leaves down the line. Otherwise, I think they're going to have a short end of the stick.
So I'm going to skip the next 3 slides because I want to talk about 2 other topics that I think are very important. One is referral fees. By all means, go get them, refer clients. That's a big part of our business, but you want to do it right. And your referral fee agreement needs to be in writing. I recommend that this definitely be a separate standalone document. You do not want this to be part of a retainer agreement, because if that retainer agreement gets voided, most likely your referral fee is going to get voided too. So standalone document and outline what the division is, that the fee is not going to be, the client is not going to pay more money as a result of that division, the terms of the division, and you make sure that they get informed written consent at or near the time of the arrangement. So if you have these things in a separate document, you're going to be fine. Refer the case, get your referral fee. If you don't, put a lien on the case, but your referral fee agreement will stand up if you comply with it.
And just to underscore 2 points, it's not enough to say, I'm going to pay a referral fee. You have to give the terms of the division of the fee. It's in 1.5.1, and it's not enough that it's in writing between the lawyers. It must be signed by the client.
And a lot of times lawyers don't want to do that. They want to say, we'll figure it out depending on how well I do or don't do on the particular situation. And that is something we find very troubling overall. Counsel needs to know they have to do it, and they're getting in trouble both sides if they don't.
And really, it's the only person who's going to lose out is you as the referring attorney. The attorney who got the case, if the referral fee agreement is voided, that lawyer is going to keep the whole fee. There's nothing that's going to happen to his or her fee and the client's portion. You can't get any of it. So your only recourse is that document and its enforceability.
Yeah,
so,
I wonder how that plays out about the Ringler case where the guy strung along the referring counsel, and the court said, you know what, ordinarily you would have required something in writing, but you were cheating him there, so we're going to upheld the referral fee. But I wonder if, you know, we've had the rule change since then, so I don't know how that's gonna play out.
And I think unclean hands is gonna play a role in any, you know, any specific fact, but go ahead, Ellen.
I was just gonna say, I mean, if you go back to Chambers versus Kay, which was another Supreme Court case, which very strictly applied the rule of professional conduct, that, you know, some would say was also unfair because the referring lawyer actually did some work on the case. There was no indication the client complained, and the Supreme Court said, sorry, the rules of professional conduct are public protection rules. You didn't comply with the rule. You didn't get it in writing signed by the client. Tough. You have an unenforceable fee agreement. Now, the law has been refined somewhat since then, but it's not entirely clear. So if you want to collect your fee, strictly comply with the rule.
Yeah. And so I want to address one other question, which is I understand that the bar is considering requiring attorneys to report other attorneys' unethical comportment with certain penalties / consequences for failure to so report. I've been in a situation where opposing counsel should have been reported, but then the lawyer would have filed meritless lawsuits forcing the reporting party to incur unnecessary legal fees. How would you deal with such situations?
I can speak to that. So this is another outcome of the Thomas Girardi misappropriation investigations by the bar. Let me digress for 1 second and say, for those of you who don't know, every single California lawyer must go on the State Bar website, log into their profile, and fill out the trust account compliance form. It's mandatory. You have to do it by February 1, although there is a grace period until April 3rd. You must do that. But in addition to that, there is now a version of Model Rule 8.3 that is being proposed in California. You can pull up the proposed rule again on the State Bar website, or if you just Google it, it'll probably pop up. The California proposed rule is quite limited. It would require the reporting of a criminal act. Now, the rule doesn't say whether, you know, it's enough for the lawyer, the reporting lawyer, to have a subjective opinion that it's a criminal act. It doesn't require a criminal conviction first, but the prerequisite is that the lawyer who's being reported is thought by the reporting lawyer to have committed a criminal act, and it requires personal observation by the reporting lawyer. So the definition of something that's known is expressly not included in the proposed rule. It has to be based on actual personal knowledge or personal observation. So it's out for public comment right now. It's on a shortened time frame. I don't recall exactly when it ends, but it's soon. So if you want to weigh in, go on the State Bar website, type in Rule of Professional Conduct 8.3, and you'll see that you can submit a comment, either pro or con, to the proposed rule.
All right, let me jump in right now. We got technically a minute left. Maybe some of you want to stick around for a little bit longer, but I wanted to just mention what I said at the beginning about the issue of fee agreements and putting in how any dispute will be handled. It is legal to say it will go to arbitration. A lot of lawyers want that because they don't want their business on the street overall. But there's also authority that if the client can't pay, the lawyer will have to pay for it, or you'll end up back in the Superior Court. So be mindful of that overall. I guess we'll have concluding comments, Marshall and Ellen.
None from me. I think arbitration, just decide whether it makes sense for you. You want to be in a private forum, probably pay more money now versus waive a jury, not have a right to summary judgment motions. You really got to consider whether it makes sense for you. It's not just arbitration is the best thing in the world. I want to do it, because it might not be right. So,
and these prevailing fee clauses, of course, you don't get fees if you represent yourself. So that may be a drawback. Ellen, anything?
My closing comment is to again reiterate, if you haven't looked at the California Rules of Professional Conduct, in particular, if you haven't looked at the new rules, please take the time to do so. It's pretty easy to take an MCLE program on the rules, and the state bar itself offers an internal MCLE program on the rules, which is open to everybody. So make sure you know the rules.
And in light of Thomas Girardi's downfall overall, you better really watch your back on client trust accounts overall. And with that, I'm going to say, how about this incredible team of people here speaking? Thank you so much. And thank you for listening.
Thank you.
Thanks, everybody.